Thank you. Good afternoon. Please be seated. Welcome to the First Court of Appeals. I am Justice Amy Guerra, serving as panel chief today. To my right, we have Justice Kristen Guinea. And to my left, we have Justice Andrew Johnson. We have one case on the docket this afternoon with two case numbers, 0124004110CR and 0124004113CR, Akintayo Taiwo Akinrinlola versus the State of Texas. Starting with appellant, counsel, please make your announcements.
If it please the court, Brian Weiss and Jonathan Zendadell on behalf of the appellant.
Thank you.
Alan Curry for the State, Your Honor.
Thank you. Each side will have 20 minutes for argument. Does appellant wish to reserve any time for rebuttal?
May it please this honorable court. If there is a fixed star in our constitutional constellation, it is that warrantless arrest may not be conducted nor search warrants issued upon the showing of probable cause. This case presents a clear and unmistakable violation of both of these consequential constitutional provisions. These convictions must be reversed for three very simple reasons. Number one, aside from appellant's mere presence at the scene, his mere propinquity, all that officers had, all of their collective knowledge, which we'll hear a lot about in a little minute, can be written on a piece of paper. This piece of paper. The state's argument that appellant lacks standing to contest the introduction of the very contraband that formed the basis for his arrest and conviction is foreclosed by the cases it fails to acknowledge and for the half-dozen reasons in our reply brief and pre-submission letter. And finally, this search warrant affidavit, with more holes than the Iraqi Navy, failed to state probable cause and is as weak, if not weaker, than the affidavits found wanting by the Court of Criminal Appeals in Baldwin and more recently in Frazier, and by this court in Glover. Stripped of the appellate landmines that we ordinarily have to contend with, such as error, preservation, and harm, this case must be reversed. The alpha and omega of the warrantless arrest issue was written by one of my heroes. I hope we're never too old to have him, because Kathy Cochran, the intellectual heart and soul of the CCA, wrote a case called Parker. And of that opinion, there are three equally compelling constraints. Number one, there's a huge difference, a gap, a chasm between probable cause to suspect that someone has committed a crime and probable cause to believe that a particular person has committed a crime. And as we say in TV, this is the soundbite from that case. Probable cause for a warrantless arrest must point like a beacon towards the individual being arrested. And in a great hypothetical, it's a little old because she uses the Astrodome. She talks about Officer Obie, her favorite law enforcement officer, patrolling section 141 of the dome, and he smells marijuana smoke. Does he have probable cause to believe somebody in section 141 is smoking weed? Of course. Does he have probable cause to arrest everybody in section 141? Of course not. Because appellant's warrantless arrest, in the words of legendary Supreme Court Justice Robert Jackson 8 years ago, was bad when it started, and it didn't change its color or character from its success.
But Mr. Weiss, wouldn't you agree that that Astrodome scenario isn't what we have here? That here we have several markers that, taken in totality, would suggest to the officer that a crime was being committed.
I respectfully disagree, Judge. I think that if you substitute Officer Obie for Officer Colley and the dome for the seawall, what we have is nothing more than the appellant's mere presence as the driver. They knew nothing more about this appellant. How do we know that? Well, don't you know that if they did, it would have been in a search warrant affidavit, and it's not. And in this situation, all they knew is that Dalton Brown, the co-defendant, his DNA was literally all over this case. Dalton Brown, not the appellant.
So I need to kind of skip forward a little bit agreeing with you that the prior information tied Mr. Brown to this transaction and that appellant was not necessarily tied to it other than having appeared at this location. But how do you respond to his behavior upon being approached by a police officer?
His behavior is exactly what anybody in that situation would do. He's told to freeze, he freezes. And above and beyond that, he doesn't flee, which itself would be consciousness of guilt. And while you have self-serving testimony from one of the officers that he, quote, believed he was going to run.
But the actual testimony is this. And I was telling him, hey, police, come here, and he wasn't listening to me. And then I saw him start to turn and look both ways. And just through my experience, that generally means someone looking for a place to run. And at that point, I drew my firearm. So here, as far as I'm concerned, we know that there's a known drug deal, drug scheme going on with Brown. We know that appellant drove him there to the scene. We know that appellant got out, and we know that when the police approached appellant, he turned and looked like he was about to run. Is that not enough probable cause for arrest? And I'm going to ask the same question to the state.
Absolutely, Your Honor. No, and for these reasons. Because in that situation, anybody confronted with a cadre of armed officers is going to react in that very manner. And the cases that we cite in our brief that say that nervousness in the face of an encounter with law enforcement is no indication of reasonable suspicion.
Isn't turning and appearing to about to run more than just nervousness?
Again, I think that that's an entirely self-serving statement of what the officer, quote, believed, close quote. I think it's conclusory, and I think that it lacks any indicia of reliability. And even if we credit that, I don't think that gets them past the red zone, let alone into the end zone of probable cause.
So one of the cases that you cited, Stoll versus State from the Court of Criminal Appeals 1989, talked about, and even if for not being relevant necessarily to the ultimate holding in that case, but a couple of things I'd like you to address there. One is, that innocent activity can be probable cause, can be enough for probable cause, and then the second one is that behavior coupled with prior knowledge. So that's the second thing I'd like you to address, which something you mentioned earlier about the collective knowledge.
Absolutely, Judge. And we acknowledge in the reply brief that Torres and Amores from the CCA were decided under a construct that is now disfavored. The notion that if conduct is as consistent with innocent behavior as with guilty conduct, basically, throw it in the dustbin. I recognize that, but I also recognize that the way that those opinions were written, you could look at that limitation as dicta, because the core holding of those cases, and certainly Torres, is that merely driving one to the scene of a drug transaction without independent facts and circumstances is insufficient. And I just don't think at this point that issue is ultimately close. And again, one of the ultimate ironies of this case, worthy of O-Henry, is that Dalton Brown is tried first, and with the help of an incredible lawyer who happens to be sitting at the table today, and with the help of a suppression ruling suppressing inculpatory text, he's acquitted. As they say around the corner, he catches the elevator with the jury. The appellant, of course, not so lucky. And ultimately, I think that it's a sign of weakness on the part of the state to claim somehow that standing should keep this court from ultimately reaching the merits of our warrantless arrest claim, and without reinventing the wheel. And I know this court and its staff have thoroughly read our briefs.
I will say, of the three issues presented, the standing argument is the least compelling, and I'd rather you spend your time on the search warrant affidavit.
Absolutely, Judge. And again, you can't challenge the inconvenient truth that the bulk of what the state has in its brief is to what the officers knew, their collective knowledge. And let's be clear, collective knowledge is not a blank tile in a game of probable cause Scrabble, all right? It's not a silver bullet. And the bulk of what the acquired collective knowledge was is after the fact. Go back and look at it. It pales in comparison to what these officers knew at the time they put the cuffs on the appellant. And at the end of the day, it's clear that the admission of the ketamine was the fruit of the poisonous tree of that warrantless arrest.
Before we move on to the search, just real quick, do you have any cases where a driver has been held, there's been held not to have probable cause as to a driver at a scene similar to this, something more analogous to this fact situation?
It is, Your Honor. And again, that's Torres. And again, I understand that it's a somewhat ancient case from the CCA, I believe written by Judge Overstreet. And I do acknowledge that there is that notion that that is consistent with innocent as guilty conduct construct. But again, I believe that's dicta. And when you look at the other companion case that we cite, and again, it's not just Torres and Morris. I think we cite 9 other cases finding a lack of probable cause on facts no stronger than these. And again, let me just say this. I have the utmost respect for my opponent. He's a legend. If there's a prosecutorial hall of fame, he gets in on the first ballot. But he's not the oracle at Delphi. We're appellate advocates, and we play the hands we're dealt. And the hand that he was dealt in this case is the 1 in 10 that has to come back. And if I could move on to the search warrant question, because I think this is an even more obvious issue. You've got Baldwin, authored by Judge McClure. You've got Glover, authored by April Ferris. And then Frazier by Judge Finley. I think everything that this court needs to know to sustain this claim, it can find in Glover, a case, again, that I had the privilege of arguing, not arguing, but being on the other side of my opponent. And the fact that they don't acknowledge or distinguish that case, to me, speaks volumes. Because if you remember in Glover, Judge Ferris points out on not 1 but 2 occasions, the state's concession, to its credit, that this was a really weak search warrant affidavit, and this court could just say, let's flip this.
What are the conclusory statements in this affidavit that you object to?
I'd say the most obvious, Your Honor, is that when questioned, Dalton Brown made statements indicating criminal complicity with the appellant. That is wholly conclusory. We don't have any of the 5 W's of the H, the how, what, where, when, and why. And that's why Glover is so instructive. The other thing I really think, if we can go back through these, Dalton Brown's name is mentioned 11 times, appellant's only 5, for driving the car, exiting the car, and being arrested. Well, again, those are the 3 runts of the litter right there. They don't do anything to advance the needle. This is one of my favorites, for not volunteering to the officers after he was Mirandized and lawyered up, that he was merely giving Dalton Brown a ride. Well, you know, I have a GED in legal studies, and I remember something about the fact of post-arrest silence. And there's a case that we cite in our brief called Law from the Court of Criminal Appeals from March of 2024. One of the few cases I've won since the JFK administration. It says you can't consider the exercise of a constitutional right, in that case, refusing to consent to a search, as any part of a reasonable suspicion analysis. How then can we use it as part of a probable cause analysis?
When was his right to counsel invoked?
When he was arrested and transported to the Galveston County Jail. In fact,
At the scene or at the jailhouse?
Once they got to the jail, and he's being interrogated, I think, by Cawley. And the other considerations in
So
this
then why,
affidavit,
in the interim between when he was arrested and Mirandized, why isn't this relevant that he didn't mention that he was just giving him a ride?
well, again, I think someone in that situation, whether they've been Mirandized or not, is going to do what they've learned from Miami Vice and Law and Order. They're not going to say anything. But the fact that you think that you can use the exercise of a constitutional right as part of a probable cause analysis when it can't be part of a reasonable suspicion analysis, no. And in Frazier, Judge Finley points out that the mere fact that the affidavit said the phone, or excuse me, the devices could lead to evidence of a crime. That's exactly what this affidavit says. That's the best they do. Could lead, and there's no showing as required by Baldwin. And again, a lot of people thought that in light of Stocker, Baldwin was on life support. Baldwin is alive and well, and that's what Frazier says.
But how do you apply Stocker to these facts? Because Stocker, the affidavit in this case seems to comport with the requirements laid out in Stocker.
Well, but again, I think you have to reconcile Stocker with Baldwin and Stocker with Frazier. And that's why we believe that the holes in this affidavit don't get it, again, into the end zone of probable cause. It's just the fact that the appellant had a cell phone with him. There's no showing that he used it before, during, or after the offense. And these conclusory statements, again, they are like cotton candy. Pleasing to the eye, but literally melting at the touch.
I mean, the nature of a conspiracy, though, is communication between the parties. Is it not reasonable to assume that they would use cell phones to communicate during the commission of the offense? Is
it reasonable? Probably. But that, again, doesn't quite get them to where they need to be. And 30 years ago, when I I was a municipal court judge, the first thing we learned is that we don't sign search warrants. We issue search warrants because you've got to do more than read the affidavit almost all the way through. Because other than sentencing, I think the most important thing that a judge does is to issue a search warrant. Because what you're doing with this piece of paper is authorizing a home invasion or an aggravated robbery. I think that the state's silence regarding Glover particularly compels the conclusion that they just don't have any answer for our second claim. The Rhode Island Supreme Court in Jeremiah said that to catch drug dealers is laudable, but to catch them by unlawful means is lamentable. In this case, law enforcement's conduct was not merely lamentable, it was unconstitutional. And we'd ask this court to sustain either or both of our claims and reverse these convictions.
Thank you.
May it please the court, my name is Alan Curry. I'm with the Harris County District Attorney's Office, and I represent the state of Texas as a special prosecutor for the Galveston County Criminal District Attorney in these two cases. It has never been our argument or my argument that the defendant does not have the ability to challenge his arrest, legal or otherwise. If my legal arguments are wrong with regard to his arrest, then anything coming from his cell phone cannot be considered by this court. If my arguments with regard to his arrest being legal or otherwise are wrong, then this court doesn't even need to consider the search warrant that searched the contents of his phone. That is not my argument. That has never been my argument, that I do not think that Mr. Weiss or Mr. Zinedell or anyone else doesn't have the ability to challenge the legality of the defendant's arrest. What I am asking this court is to look at the facts and realize how the evidence was obtained in this case. The two individuals were arrested separately. The defendant did not have the co-defendant's cell phone on him. They were arrested separately. The defendant did not have the ketamine on him. The only way we can prove the defendant's culpability for the ketamine, only as a party, is the text messages that have come from the co-defendant. They reveal that the defendant actually is the mastermind. He is the one who is running this entire show. He believes that he is going to be the one who's going to be in charge of this whole operation. The defendant, as all of the case law I've cited, Padilla and otherwise, reveal that he does not have standing to challenge what happened to Mr. Brown. He doesn't have standing to challenge the recovery of the cell phone, and he does not have standing to challenge what the drugs that were recovered from Mr. Brown. They were arrested separately, both in time and in place. They were there together, and we contend that they were together in this criminal enterprise. But that is a separate issue from whether or not the defendant can complain about what happened to Mr. Brown. He cannot, and that is clear law. I am not at all opposed to defense presenting the most recent decision of the Court of Criminal Appeals in Pettit. That case stands for the unremarkable proposition that a defendant, a passenger or a driver, has standing to challenge the stop of a car. Of course he does. Of course Mr. Akinrinlola has the standing to challenge his arrest if he believes it was illegal. That is only my contention. So it would be my contention that the strength of the state's case with regard to the possession case is based upon the co-defendant's cell phone, the contents of that cell phone, and the fact that ketamine was recovered from something apart, completely apart from the defendant's arrest. Having said that, the state still does believe that the officers had probable cause to conduct a warrantless arrest of the defendant. These two individuals arrived together to conduct what the officers knew was going to be some sort of transaction in which a large amount of ketamine. This is not a few grams of cocaine. This is not a pound of marijuana. This is several million hits of a very powerful controlled substance brought in from another overseas. So when these individuals arrive together, they appear to be acting together. One goes in to obtain the substance and the other one walks away, and we don't know why he leaves, but he goes to walk around. He is not just a driver. He is not just showing up just to see what the parties are doing. But he arrives to help, and the officers could reasonably believe that he was arriving to help Mr. Brown gain possession of this substance.
So what was you're saying that him getting out of the car, can you point me specifically to what behaviors when he got out of the car showed that he was acting in concert?
Nothing, Your Honor, but my point is that he did not arrive here just sitting in the car waiting for the co-defendant to come back to the vehicle. He got out. He was comfortable going to the hotel. I don't know whether he was casing the joint. I don't know what the officers reasonably believe. They didn't tell us.
Well, according to the evidence, when he got out, Officer Colley, I believe, said he didn't have anything in his hand, and then when he, confronted him finally, he had a water bottle in his hand. So
right.
Maybe he just got out to get a drink of water.
Maybe he did. Maybe that's all he did. We don't know.
But how significant is his interaction with Officer Colley when Officer Colley approaches him and asks him to freeze? The testimony from the officer that he looked both ways.
I believe it was the other officer, Your Honor.
Sorry.
But in any event, I think that is the more telling of what we're looking for, a consciousness of guilt. Mr. Weiss has pointed out in his opening that the defendant did what any one of us would do. I disagree. If a police officer tells me to stop, I'm going to stop. If I'm acting with innocent activity, quote unquote, now I'm going to stop. And I'm definitely not going to look around. I'm definitely not going to freeze and decide whether or not I'm going to obey this officer or not. I'm going to obey him.
Do you have any case where, as far as I'm concerned, as I said to counsel, here's the universe that I see here. There's a known drug scheme going on with Brown. We know that Brown's involved in that. We know that Appellant is the driver. The only other fact I really see that goes towards probable cause potentially is that when the officer comes and says freeze, he looks both ways and it appears to the officer, based on his experience, that he's going to run. Do you have any similar case in this situation where probable cause was upheld?
No, Your Honor, I don't. I fully admit that, I've cited to you what I've cited. I've got plenty of experience, and Pringle is the closest case I can come where there's multiple individuals involved, and the court held that it was reasonable for the officers in that case to rely upon the idea that they were all three culpable, at least for the purposes of probable cause. And that's all we're looking for here. Was it reasonable for the officers to believe that this defendant was involved with what Mr. Brown was doing? He was not just the driver. He was not just sitting in the vehicle. He got out. But the most important part is that he did do something that I don't think a reasonable individual would do. And certainly the officers reasonably believed that he was, at least had some consciousness of guilt and when he acted that way. But do I have great cases to cite you? No. But the innocent activity, which Mr. Weiss admits is no longer favored, it's not just dicta. The case law is clear that you look at the totality of the circumstances, and an officer is not required to reject every possible innocent explanation as he is making split-second decisions there at the scene. If something could be reasonable, was he going to just get a bottle of water? Sure, he may have been, but that doesn't mean that you discount everything that the officer saw that could happen to have a innocent or a reasonable expectation, a reasonable inference from the defendant's standpoint. So it's our position that when you evaluate what an officer did, you evaluate all of the evidence, totality of the circumstances, as the case law puts it, and you evaluate all the officers knew, the collective knowledge doctrine. And all of these officers were seeing various bits and pieces of what they were seeing. Is this the greatest case they've ever seen? No. But it is enough for probable cause. Were these officers acting reasonably? And I believe that they were. With regard to the search warrant, I am constrained by the holding in Baldwin. I was pleased when Stalker was issued. I was less pleased when Frazier was issued. I fully admit that. I do not know what the current state of the law is with regard to what the Court of Appeals would like to see. I don't know that this case is a fantastic vehicle for me to evaluate the validity or the scope of Baldwin. I would like to do that someday. I just don't know if this is
Well,
the
let me
case.
ask you this. In the search warrant affidavit, there's this main paragraph in the middle that kind of, I think, is probably the most important paragraph. The officer that signed the warrant says that it was discovered that the defendant was not an unknowing passenger. This conclusion was formulated based on three things. One was that his inability to state he was just giving the ride to Mr. Brown. Do we agree that we can't really consider that? That's just his right to remain silent?
The only reason I hesitate, Your Honor, is I do see some cases talk about the defendant's explanation or lack thereof.
But that might
I
be
do
where they
agree
actually
that
conferred.
from the timing, it's not fully fleshed out in the record, but the timing does appear to be something that occurred when he would have had the right not to say anything.
Okay.
So if he was saying a bunch of things and then didn't say something, that might be still telling. That might be something you could rely upon. But if he didn't say anything, I'm less convinced that that's something that you would want to rely upon.
And I tend to agree with you on that. The next is statements of a conspiracy made by Brown which implicate defendant's involvement. What statements, what does implicate mean? How is that not conclusory?
Well, I don't deny that it's conclusory, Your Honor, but the fact is that Mr. Brown did suggest some things in the totality. I'm not saying that it's not conclusory. I'm not saying that it is conclusory.
Aren't we constrained to the four corners of this?
Yes, you are. You are, but the issue I'm saying here is that Baldwin says something is boilerplate. I don't agree with that. That's the law right now. That is the law that you're bound to follow. But even Baldwin says that when something you see is boilerplate or conclusory, that doesn't mean you ignore it. That just means that you give it a great deal of less weight than you might if something more specific was said. This individual implicated the defendant in the scheme that the officers were investigating. Was that conclusory? Would I have liked Mr. Brown to spell out the fact that the defendant was the mastermind? Sure. But does that mean that you completely ignore everything the co-defendant told the officers? I don't agree with that either.
Does it matter that that he doesn't say whether that Mr. Brown was reliable or?
Well, typically, Your Honor, and I don't know that we briefed that, but you will find cases that will tell you that a co-defendant, if he gives his name, can still be reliable. It can be someone that the officers can rely upon. The general rule is a named individual can have some reliability to them. And there is case law, and I can provide it to you if you need it, where even a co-defendant's statements can be something that the officer can reasonably rely upon. In light, I'm not asking this court to overrule Baldwin. You can't. I'm not asking this court to overrule Frazier. You can't. I'm not asking this court to add some things to Stalker that the Court of Appeals didn't say. You probably can, but I wouldn't recommend it. Acknowledge that the same other courts that have construed the United States Constitution, and I have cited to this court some federal Court of Appeals decisions that have relied on the same kind of wording that we have in this affidavit, that would be sufficient under the U.S. Constitution according to those federal appellate courts, which I think have at least as much experience as the Court of Appeals does in evaluating. But even under Baldwin, I believe that there is some way of looking at this. The fact that the co-defendant was using his cell phone, the fact that they had cell phones on them at the time, they were utilizing a common approach. I think the officers were reasonably justified in saying so. And then the co-defendant confirms that when they talk to the co-defendant. Again, conclusory, sure. Did he specify? No. But was it something that the officers could rely upon in looking at the totality of their circumstances to give the magistrate enough information to believe that they had probable cause to look through the cell phone? The defendant's cell phone helps us get information with regard to the other charge, the engaging offense. The co-defendant's cell phone largely focuses upon the actual possession that happens in Galveston County. The two, there are some overlap, but primarily the analysis of the two phones seems to be focusing on two different offenses. I don't know if the court wants to look at it that way or not. I'm not asking the court to do that. I do believe that this case, even under Baldwin, is sufficient. Am I happy about making that argument? Not particularly, but I do believe that even under Baldwin, that this search warrant is sufficient because some additional facts that are put forth by the officers. And pointing out that Baldwin does not tell you to ignore what they call boilerplate. They just say it's not enough. And I don't disagree with that.
If we were to find that the search warrant was deficient, what would that mean? Would that mean because the other text messages from Brown's phone came in that we would potentially affirm as to the drug charge and reverse and remand as to the organized?
Theoretically, Your Honor, and I have conceded error in cases before. I am not doing that now, but your analysis is not incorrect. I mean, that is something that could be done. I'm quite certain that Mr. Weiss doesn't want you to do that. And I will tell you that I prefer that you wouldn't do it either. I think that we have enough here for the state to be able to prevail. I think the magistrate had enough in order to find probable cause based upon this warrant. Mr. Weiss has referenced the Glover decision in which we went up against each other, and I essentially conceded error in that case as to the warrant. I would just ask you to look at the warrant in Glover and even, briefly compare the two search warrants. There's no comparison. There's no comparison. The warrant in Glover was, I made an argument, but the warrant in Glover was not great. This warrant, I believe, would satisfy the federal appellate court decisions that I have cited. I believe it would satisfy Stalker to the extent that Stalker tells us what the law is. Stalker was not overruled by Frazier, and I do believe that it satisfies Baldwin, especially if you look at all three decisions together to the extent that you can. And I would urge you to uphold the search warrant on that basis, at least with the idea that this magistrate had enough deference to the magistrate, totality of those circumstances, to believe that there was evidence of criminal activity on this defendant's cell phone.
Mr. Weiss didn't talk about it in his opening, but can you briefly address the ineffective assistance of counsel claim?
Yes, Your Honor. A couple more things I may want to say about other issues. Ineffective assistance of counsel. The objections made in this case were sufficient. By that, you should not take from me any suggestion that I'm providing a ringing endorsement of the actions of defense counsel at trial in this case. But I do believe that they were sufficient. The defendant has the burden of proof, and the defendant has to establish both prongs. Case law is clear that a defense counsel, whether he makes a half-hearted objection or makes no objection whatsoever, if the evidence is admissible, then it does not matter with regard to Strickland that he didn't make a great objection or he didn't make any objection at all. Both of those situations appear to apply in this case, either not making an objection or not making a great one. But certain things he did object to, and certain arguments were made by the state, such as the standing argument that I continue to rely upon. But the defense also has to establish the second prong to prove that this would have made a difference in either one of the two convictions, that this would have reduced confidence in the outcome of both decisions. If this evidence was admissible, notwithstanding what objections were or were not made, then it doesn't really matter that he didn't make the appropriate objections. With regard to other more minor claims that Mr. Weiss has raised, I presented arguments as to at least one situation in which the co-defendant expresses fear from the defendant. There is plenty of case law that says that fear of a defendant can be something that can be admissible under that hearsay exception. But I think primarily with regard to the non-Fourth Amendment issues, I think this court should be able to rely upon the second prong. If I lose on the admissibility issue, then obviously it's going to be much easier for you to sustain the third issue for review. But I do believe there's a sufficient amount here for this court to be able to justify this conviction and see that this defendant did receive a fair trial in both cases. Mr. Weiss has pointed out the fact that the co-defendant was acquitted. I would urge this court not to consider that. That doesn't have any role on the legitimacy of what happened in the defendant's case, either with regard to any particular action the officers took. Mr. Weiss has referenced the innocent activity construct that he acknowledges was disfavored as dicta. The state respectfully disagrees with that characterization. Unless the court has any other questions, the state will urge this court to affirm both convictions.
No questions. Thank you.
May it please this honorable court. We heard a little jury argument today about the appellant being the mastermind. Well, that's as irrelevant as last week's lotto ticket. They didn't acquire that information until after this warrantless arrest. I asked the court to disregard that. They weren't arrested separately. They were arrested feet apart at the same time. It was simultaneous. We acknowledge we don't have standing to contest the legitimacy of the seizure of Dalton Brown's cell phone. Of course, that's rapist. But we certainly have standing to contest the admissibility of evidence seized from his cell phone. And make no mistake, there were enough inculpatory text messages on the appellant's phone that contributed to this conviction. And the state may be trying to back away from the fact that they didn't brief harm. They didn't brief harm under Glover. That's a concession of error. The state basically wants this court...
Wasn't this court required to determine harm regardless? I mean, even if the state doesn't make an argument about harm.
Well, I only know what Glover says. I mean, certainly it's this court's independent duty, but Glover makes it clear that this court doesn't act as an advocate for the state when it's abandoned the effort at briefing the issue of harm. The state alluded to the fact that appellant was, quote, casing the joint. I mean, that's conclusory from where I am. The fact that he was out taking a walk and then the state acknowledged we didn't know what he was doing, that's it. We don't know what he was doing. And that's nothing plus nothing ultimately equals nothing. You know, I don't often get to quote Nathan Hecht, but in Burrow versus R.C., Justice Hecht said, we can't credit a witness who simply says, you know, take my word for it. Credentials qualify a person to offer opinions, but they don't supply the basis for those opinions. What am I talking about? Oh yeah, that would be the search warrant affidavit and the fact that he believed the defendant was going to run. And Justice Johnson, this is far too slender a read to legitimate this warrantless arrest because the defendant hesitated and maybe looked both ways. We don't know. How would any of us react in that situation? That again is something I don't think ultimately drives the resolution of this issue. I think it's also the height of irony to ignore, not to ignore, but to meaningfully distinguish or fail to Baldwin and Glover and Frazier, and then rely on, of all things, federal court opinions from the Ninth Circuit Court of Appeals. Really, that is not something that I would suggest this court hang its collective hat on. The current state of the law, as I see it, you know, first in, first out, it's Frazier, it's not Stocker. And to his credit, Judge Finley went to great lengths to point out that, you know, Stocker says this, but Baldwin basically says this is what the standard is, and they haven't made their way around Frazier. I asked this court to take this opportunity to clarify the law. You know, and I remember at the motion from your trial hearing, I closed with Herb Brooks and the famous Miracle on Ice speech where he told the kids that went out and put a beat down on the Russians, great moments are born from great opportunity. And that's what this court has in this case. Justice Johnson, if this court were to sustain the second issue involving the cell phone, it would reverse and remand for a new trial. But again, there's no question but the fact that the appellant's text messages contributed to his conviction under 44.28.
On both convictions? On both convictions?
That's an interesting question. I mean, my position is you've got the spillover effect that we see in federal court. And there's no way of knowing because we can't get juror affidavits that would allude to.
But if you already had text messages from Brown implicating him as the mastermind in those texts, as far as the ketamine was concerned,
Well,
I think it'd be a hard thing to find harm there.
we are not willing to concede the fact that it would only impact one conviction.
Understood.
The state continually used the expression, the officers reasonably believed. That to me sounds like reasonable suspicion. When you use the word reasonable, probable cause is a far greater burden than reasonable suspicion.
It's greater. I don't know that it's far greater.
It's enough, Your Honor. So I certainly think sustain what it is that we're contending. The IAC claim, Your Honor, I think this court doesn't need to reach the merits of because I think it will sustain either the warrantless arrest issue or the cell phone warrant issue. And I want to say one thing. In 45 years of doing this, I've learned that compelling legal reasoning is just not in the pages of Southwestern 3rd or Southwestern 2nd. Noted legal sage Chris Christopherson in 1970 said, because the laws for the protection of the people, rules are rules as anyone can see. Well, the laws for the protection of the people like this appellant, and the rules that are rules as anyone can see were the rules that law enforcement violated in this case. This court may not like it, but if it liked everything that it ever did, it's probably in the wrong profession. I ask this court, for these reasons, to sustain our claims and reverse these convictions.
Thank you both sides for your arguments and your briefing. The case is submitted and we are adjourned.
All right.